Good afternoon. It's nice that it's light. So late these days, maybe spring will eventually come to Chicago. We are here on the happy occasion of welcoming you to the third annual Robert Kirshner Memorial Lecture in Human Rights. Our first lecture under this series was 3 years ago. We had our neighborhood and nationally famous novelist Sarah Paretsky, who last year came and introduced our second speaker, Alex Kotlowitz, who will be up here in a moment to introduce our third speaker, Juan Mendez. This lecture series is part of the Human Rights Program's annual activities, which include courses, public events, and a set of internships which send 25 to 35 University of Chicago students off on life-transforming experiences in the summers. This series exists through the generosity of Bob Kirshner's family. Bob Kirshner was a beloved person on our faculty, a creative and thoughtful forensic pathologist, a wonderful teacher and mentor. And we are very pleased that his wife, Dr. Barbara Kirshner, is here tonight, along with his son, Dan Kirshner, Dan's wife, Emily, their daughter, Madeline. Madeline, you want to wave to people so they know you're here? Bob's sister-in-law, Kay Kirshner, came in from out of town, and his favorite cousin, Andy Stone, is also here. And it was a fund put together by the Kirshner family and friends of theirs. Many of you are here. There are too many of you to name individually. That has enabled us to have this wonderful lecture series. In fall of this year, we will be doing a conference on torture, which is very timely because we did one 10 years ago in which Bob was a very active participant, called Investigating and Combating Torture. And this year, 10 years later, having had no idea 10 years ago what would happen on the issue of torture. In fact, a speaker from Amnesty International at that conference predicted the end of torture and what was Amnesty going to do with their agenda. They were unfortunately wrong, and we now will come later this year together with the group of practitioners and scholars to talk about overcoming torture. So our speaker tonight, Juan Mendez, will help us understand a few of those issues about what one does in a transitional moment. So I just wanted to remind all of you, and you can tell anybody who comes in later, that this talk is being recorded. It will be available as a podcast on the university's website so that you will be able to tell your friends who didn't make it what they missed and that they will be able to catch up with the program at their leisure. They can have it on their iPods, they can watch it on their computers, whatever they want to do. It's a terrific technology for us to be able to share these events with people beyond these four walls. Now, it's my great pleasure to introduce our introducer, Alex Kotlowitz, who was the lecturer last year at the second annual Kirshner Lecture, is well known to people in Chicago and around the nation as a writer. He has written at least 2 books that have been widely discussed and widely circulated. There Are No Children Here, regarding the situation of children in public housing in Chicago, the story of 2 boys who he got very close to over a 2-year period, and a book called The Other Side of the River about race relations in southwest Michigan, just around the curve of the lake from us. Alex is a frequent contributor to the New York Times Magazine. His most recent piece a few weeks ago was on the foreclosure crisis in Cleveland. He's also now branching out and will be co-producing a film with Steve James of Kartemquin Films about the ceasefire efforts in bringing an end to youth violence in Chicago. And so it's with a great deal of pleasure that I welcome our second Kirshner lecturer to introduce the third Kirshner lecturer, Alex Kotlowitz. Yeah, it fell apart.
I feel like it's kind of one of these Russian dolls, you know, the first lecturer introduces the second, and the second the third. And, well, it's my honor and privilege to be introducing our guest tonight, Juan Mendez, who will be delivering the third annual Robert Kirshner Memorial Human Rights Lecture. You know, Bob Kirshner always had exquisite timing. He seemed to know instinctually when he was needed. He also instinctually understood that in order to manage the present and to secure the future, that we first had to acknowledge the past, and that's the power of Juan Mendez's work. He, like Bob, won't let us forget. Juan Mendez, from his time imprisoned in Argentina, knows firsthand the need to address the past, to bear witness, to testify. Truth-telling, Juan has written, has been difficult but is now largely recognized as necessary. Like Bob, Juan Mendez has shown amazing courage and tenacity in his efforts to piece together the narratives of the forgotten, those whose stories would otherwise disappear into the ether of inhumanity, those whose stories would be rewritten by those in authority, those whose stories are essential to a society finding its way with dignity, with decency, with honor. You know, when I consider Juan's work, I think about that old William Faulkner line, that the past isn't dead, it isn't even past. Juan has shaped his life around trying to ensure that we find ways both to talk about and acknowledge the past, as well as finding ways to hold people accountable for the pain and suffering they've inflicted on others. He won't let us turn our heads from that which discomforts. Those who have committed crimes against humanity may try to slip away. They may try to reframe their place in history. They may, in fact, try to rewrite history. But Juan won't let them. He insists that we face the truth. It is, as he says, necessary to who we are, necessary to moving forward, necessary to the maintenance of the human spirit. Juan now directs the International Center for Transitional Justice, and his work and their work is essential in these times. They've addressed human rights crimes in places as diverse as Rwanda, South Africa, and Peru. And we lean on Juan. We need Juan. He has such important things to tell us about how we deal with this transitional moment in our country, how we wrestle with the violation of human rights by our own leaders, how we make sense of the recent past, how we hold accountable those who wandered from the ideals and promises of the Constitution. Juan Mendez, like Bob Kirshner, is a hero. His persistence, his courage, his unflagging commitment to human rights inspires us all. And with that, I'd like to bring up Juan Mendez.
Thank you. Thank you all for being here, but especially thank you for those very kind words. I am very deeply honored to be invited to the third Kirshner Memorial Human Rights Lecture. Honored because of the event itself, but also very personally gratified because I had the immense privilege of being a friend of Bob's. Actually, he favored me with his friendship, and I also admired his work in many different settings, particularly this question about holding people accountable and making sure that the truth is not covered up. You can't imagine how much our efforts were invigorated and made a lot more scientific and therefore persuasive and in fact undeniable by the efforts of Bob Kirshner, Clyde Snow, and the many other forensic anthropologists that suddenly came into the human rights field and gave us these wonderful tools. They are wonderfully sad and painful, but they are incredibly powerful as well. And so it is a real privilege to be a lecturer in this series. I met Bob in 1989, and the circumstances, could not have been more telling of the kind of person that Bob was. We were participating in a teaching course in Costa Rica at the Inter-American Institute on Human Rights, and he and Clyde Snow and others were teaching forensic anthropology that was beginning to be used in human rights work at that time, when news that the Jesuit priest had been killed in San Salvador with their housekeeper and a teenage daughter of the housekeeper. And Bob and his colleagues so impressed all the people in attendance because they stopped what they were doing and just jumped on a plane and went to San Salvador in the middle of the so-called offensive, when there were street battles, literally street battles in the middle of San Salvador, and Bob was there before anybody else. And years later, I was the director of the Inter-American Institute on Human Rights, and living in San Jose, Costa Rica, and I heard that Monsignor Gerardi, another hero of human rights and accountability, had been killed 2 days after he had produced this seminal report on the violations against the Mayan people called REMI, Recovery of Historical Memory. And obviously I went immediately. I took the first plane, and as I was telling Bob's family, Bob was already there, had come from Chicago before me, and he was already doing investigations. He was already determining how badly the crime scene had been mishandled purposely. And so I credit Bob with not letting the criminals in Guatemala and the powers that be in Guatemala, because there's a lot of complicity in letting this crime go unpunished, letting this crime be denied, be falsified with false accusations against innocent people, etc. So that's why I hope you will bear with me if the occasion is a little personal for me. Nevertheless, I'll try my best to honor the occasion and the memory of Bob Kirshner. I also have to apologize in advance if my presentation it sounds a little disjointed, because the topic is prevention, peacemaking, and transitional justice, and I will talk about that. But I also feel very strongly that these things have to be put in the context of how do we create effective conditions so that we can do prevention of human rights violations and we can do effective peacemaking and peace building. And one of those conditions is American leadership, quite frankly. American leadership that has been absent for 8 years, and that has to happen again. We have an opportunity now to create the leadership that the world needs to do effective prevention, effective peacemaking, and effective transitional justice. But the first condition is that the United States reckon with its own immediate past. And so the second part of my presentation is going to be about how do we produce accountability for the violations that have already occurred in the so-called global war on terror. So it may seem like a topical departure, but I think I made a case for it. My point of departure is that prevention of human rights violations is something that has bedeviled the human rights movement forever. Back in the 60s, the human rights movement grew because it found a methodology to react to violations, to monitor them and to denounce them and to make sure that they don't go forgotten. That methodology was later refined to determine what the appropriate remedies that states owe to victims of human rights violations should be, and to lobby very aggressively for those remedies to be effective. But we never really, we were always asked from the start, what about trying to make sure that these violations don't happen in the first place? And we really never really came up with an answer. And then in the 90s we had these terrible, catastrophic events of Srebrenica and Rwanda, and then the United Nations, was kind of forced to reckon with prevention. In the 90s, the discussion within the United Nations was mostly about prevention of conflict, but it soon turned to prevention of at least the most important human rights violations, the so-called mass atrocities, and particularly genocide. And I was very honored by Kofi Annan to be named his first special advisor on the prevention of genocide, and it was a great honor, but it was also a very difficult task, the most difficult job that I've ever had, and one in which we had to sit down and say, well, how do we do this? And what I'm going to share with you are some lessons learned in those 3 years in which I acted as the Special Advisor on Prevention of Genocide, visiting places like Darfur in 2 occasions, and trying to determine what is it that the international community can do to prevent mass atrocities from happening. In the context of that, the international community came up with this emerging norm. I'd like to call it a norm. Some people dispute that it is, but at least an emerging principle called the responsibility to protect. Of course, that doctrine was in the making for several years before, but in 2005, there was a World Summit to discuss the reform of the United Nations that generally failed in every aspect of it, except on responsibility to protect. There, with about 100 heads of states and government present, the world community unanimously said that when it comes to very serious human rights violations, including genocide, war crimes, crimes against humanity, and ethnic cleansing, there is a responsibility to protect civilian population that can be vulnerable to those kinds of atrocities. And that responsibility to protect is now under fire, but it is an important moral, and I would say emerging at least as a legal principle that we can use as a normative framework for preventing human rights violations of this kind. When I was first appointed, the worst of what happened in Darfur had already happened. The 200,000 or so murders happened in 2003 and early 2004, and I was only appointed in the summer of 2004. So some people said, don't do anything on Darfur because that's already happened. But in fact, if you look at the recent episodes, there is genocide happens where there's been a precursor, and without having to debate whether what had happened in 2003 was genocide or not, it was clear to me that it could happen all over again, and that it could be worse as well. So there was no sense in saying, well, we arrived too late to Darfur. So a lot of the work that I did with my colleagues during those 3 years was referred to Darfur, and the changing landscape of what the international community was trying to do to protect the people, now almost 4 million Darfuris, who are in very dire need of protection, but also many other things that the international community has to do for them. And it was in that context of trying to look at firsthand at what needed to be done that I came up with the idea that we have to act comprehensively and in a coordinated fashion in 4 different areas. And those 4 areas, or that rule basically applied to other places other than Darfur during my tenure as Special Advisor on the Prevention of Genocide. And those 4 areas are, first, protection. And by protection I mean physical protection from harm, literally armed protection to make sure that those who are going or trying to commit atrocities against a vulnerable population have to reckon with having to fight their way into that atrocity because there are people there protecting them. And there, the story in Darfur has many ups and downs, and unfortunately now more downs than ups. But it's very clear to everybody that the vulnerable civilian population has to be protected, and meaning physically protected. It doesn't have to be by troops, but it has to be by a sufficient deterrent force. Could be police that really protects them effectively. The second area is humanitarian relief, because by and large these populations are vulnerable to many different ways, to many different things, and not only to mass murder, but especially in the case of Darfur, it's very visible that there's a kind of a death by attrition that happens by the fact that these people have been displaced, that they are in internally displaced persons camps, and that in those places they may or may not get the assistance that they need. and most recently after President Bashir reacted to his arrest warrant by the International Criminal Court by expelling several humanitarian organizations, the situation has become even more dire. And quite frankly, because the way humanitarian relief is administered in today's world affords a measure of protection as well, because it is done by many human rights organizations, humanitarian organizations, whose personnel is present there and by the witness themselves are already protecting. The third area is peacemaking, because the underlying conflict that has given rise to the danger of mass atrocity has to be dealt with, and has to be dealt with in its root causes and in all its manifestations. So we have not only to protect people and to give them humanitarian aid, but we also have to try to address the root causes by settling whatever underlying conflict may have been the cause of it. And by and large, in places like Darfur, but also even in Rwanda, there is an armed conflict that has to be settled in as favorable a way as possible. But then the fourth area that I want to insist on is accountability, because by and large, crimes have already been committed and they're very serious. And the perpetrators are still around and powerful, and they're ready to commit atrocities anew. And if you don't provide accountability for the crimes that have already happened, one, they could happen all over again, but even if they don't, it just makes everything else much more difficult, because the vulnerable population cannot trust that the international community is doing the right thing when they can see their Janjaweed coming to the IDP camps and threatening, and perhaps even worse than threatening. They can see them raping their women when they go out to get firewood. So if you don't settle the question of accountability for the crimes already committed, the conflict goes on, and it gets worse all the time. And that's why when the High Commissioner for Human Rights and I went at Kofi Annan's request to Darfur the first time, and we were able to brief the Security Council on our return. This was October of 2004. The first thing that we both said to the Security Council is that there had to be accountability for the crimes already committed. And that led us to be the first UN officials to argue for the referral of the case of Darfur to the International Criminal Court, which happened, as you know, 4 or 5 months later on 1st April 2005. Unfortunately, she and I were also the only ones who after that continued to say it's not just a question of referring the case. Now we have to support the ICC, and we can't let the government of Sudan get away with not letting the prosecutor and his investigatory teams come to Darfur and investigate the case, which in fact, unfortunately, the Khartoum regime has gotten away with, because there was complete silence from the Security Council and from many powerful nations after the referral was done, as if sending the case to the International Criminal Court was all that you needed to do to produce accountability and to protect people. So anyway, these 4 areas that I use mostly in the context of prevention, I think they're also present when we're talking about putting an end to a conflict. So when we talk about peace and justice, we might as well be also talking about prevention and justice, because in the case of Darfur, for example, there's no peace accord a real peace accord that we need to discuss. But in places like northern Uganda, for example, the possibility of a peace accord with the LRA has brought a lot of people to say, well, then we need to give Joseph Kony a break, and if he wants an amnesty, he should get an amnesty, and we should not let justice interfere with settling this very cruel 21-year-old conflict. Now, there is a temptation then that peace always should trump justice, and in fact that's the way until about 10 years ago most conflicts were resolved. The minute a really murderous group decided that they were tired of fighting, and they wanted to sign in the dotted line, they also asked for amnesty. They also asked for other things, like, you know, a house by the lake and a ministry, etc. And unfortunately, they generally got it. But starting in the 90s, I think with the evolution of the normative framework about mass atrocities, but also with the perception by the international community that accepting this kind of blackmail from people who commit atrocities was just not a good idea, not only morally but also practically. I think the best example is in 1999 when the Lomé Accord that put an end to the Sierra Leone conflict gave an infamous warlord called Foday Sanko everything he wanted after, you know, cutting children's arms, kidnapping young girls for sexual slavery, etc. He still got amnesty. 6 months later, he was fighting again, and therefore, you know, the perception was that, you know, an unjust peace is also not a very lasting peace, and therefore it just cannot be relied upon to produce the results that we all want. And so, I think, in fact, that doesn't mean that we should not recognize a dilemma. I mean, we in the human rights movement should not ever let ourselves be painted into the corners as being the enemies of peace. But the fact that there is a dilemma doesn't mean that that peace, under any cause, under any circumstance, should always trump any possibility of justice. What we need to do is first not yield to blackmail, as I already said. Most recent example is startling even to me, who have, you know, I've been working 30-some years in human rights, and I've never seen something like this. You may have read in the New York Times only a few days ago that in Zimbabwe, the generals that surround Mugabe are actually kidnapping and killing some of his enemies in order to get an amnesty, as a bargaining chip. You want to be left alone. You don't want to be kidnapped and killed. You don't want to be arrested and thrown in jail with false charges. Then give us an amnesty. I mean, it's the most outrageous form of blackmail that I can think of, and you know, it just makes us think. You know, why should we yield to that kind of blackmail? But in addition, as I said, there are emerging principles. Crimes against humanity and war crimes. And then we can decide what constitutes a crime against humanity or not. But these very serious atrocities, just to give it a non-technical name, either whether they happen in the context of war or not, their impunity is unacceptable to the international community and to the law. There's very clear international law rules that say that they just cannot go unpunished, that there are affirmative obligations on the part of the territorial state, but also on the part of the international community to make sure that impunity for those crimes does not prevail. And that presents a framework under, that kind of restricts the ability to give amnesties in the context of putting an end to a conflict. It may make peacemaking more difficult, more complicated, but I submit that it's good. You know, it doesn't let us get away with the easy way out of giving amnesty for these atrocities. Now then, the real dilemma is, how do you make sure that you get peace without closing the doors to justice? How do you make sure that if you can't get justice now, at least you don't deprive the victims of some ability to obtain justice down the road? And that doesn't mean that amnesties by themselves are always and under all circumstances prohibited. What are prohibited are amnesties that are blanket amnesties, because they don't demand anything from the perpetrator, that they're unconditional, and that they have the effect of creating impunity for mass crimes. Other amnesties that can put an end to the conflict are acceptable. In fact, I would say more than acceptable. They're actually urged by international law, especially the Geneva Conventions dealing with internal conflict actually have a norm, the protocol, the additional protocol, to the Geneva Convention has a norm that says that at the end of an internal conflict, the parties will give each other a generous amnesty. But clearly, that refers to the crimes of rising up in arms against the state and similar lesser crimes, but it does not refer to mass atrocities or very serious war crimes. Now, here is where transitional justice enters the picture. Because even if we do prosecute Coney and now another guy, because of the 5 he has already killed 3 himself, but if we prosecute them by the International Criminal Court, or if we prosecute Bashir and the other 2 defendants in Sudan, by definition it will only be just a handful of the perpetrators, not all of them. And even if we're successful in getting the domestic jurisdiction of a country to provide accountability, it will still be, by definition, a relatively small number of defendants who will face justice. And that will leave many victims unsatisfied, either because their particular case was not properly heard, or because the particular perpetrator that affected them and their families was also not investigated and prosecuted. And that some people call that an impunity gap. Now, in some cases, as I said, it's almost inevitable. Even, the fact every country in the world prohibits murder, but we haven't abolished murder. It still happens, and judicial systems deal with a certain percentage of the murders, but not all of them. But in cases of mass atrocities, of reckoning with legacies of very serious abuse of this sort, it's important that the impunity gap be, at least as lessened as much as possible, diminished as much as possible. And there, the international law has been evolving towards creating a more comprehensive, more balanced, more, if you will, holistic approach to justice that is not just prosecuting only the top perpetrators. It is, but I want to specify that prosecution of those bearing the highest responsibility for the most important crimes is still central to transitional justice. I want to disabuse anybody of the idea that transitional justice is a kind of a soft form of justice, an alternative to prosecution. It is not. What it is, however, is a more comprehensive look at justice that insists on several non-judicial ways of dealing with the legacy of abuses of the recent past. And one is to investigate and disclose the truth of what happened. Because many of these crimes are surrounded by denial, by oblivion, by an attempt to cover up, etc. And so insisting on telling the truth, it doesn't have to be through a truth commission, it can be by other means as well. But making sure that if we know the tip of the iceberg, the rest of the iceberg is also visible, is actually an affirmative obligation under modern rules of international law. But it's also reparations to the victims that have to be such that they, don't insult the dignity of them as victims and as first-class citizens, which they should never have been any less. And third, institutional reform, because the institutions of the state that have been the vehicle for human rights violations, like the police or the military, sometimes even the judiciary, have to be thoroughly reformed so that they cannot be in the future vehicles of those violations again. And some people talk about reconciliation. I would say reconciliation is not mentioned in any of the legal precedents that I'm not spending any time spelling out for you, but from where these principles arise. But undoubtedly in some conflicts, like Darfur, for example, where the violations have a clear ethnic dimension and where communities have been pitted against each other, such that the atrocities committed in the name of one community against another will be visited onto the generations that come later, like in the former Yugoslavia or now in Darfur. Then, in addition to prosecutions, to truth-telling, to reparations, and to institutional reform, we also must do some reconciliation work. And I would say, for example, in the case of Darfur, that reconciliation has to take the form of intercommunal conversations dealing with restitution of property, with return to villages and to land, with grazing rights for cattle, with passage rights for cattle, with water rights, because in that fashion, if those conversations happen and they're serious and they're not interfered with by the government, then you can expect that at the end of the conflict, these communities are not going to hate each other for generations to come. So where does the United States figure here? Well, obviously, it figures because the international community needs the United States, and the United States needs to be able to lead in these efforts. And now with the Obama administration, we have an opportunity because there's a clear commitment to multilateralism to begin with, but also to the use of force strictly in self-defense, or at least as strictly as possible, certainly in non-aggressive circumstances, which is a great departure. There's also an attitude of dialogue with cultures and with other peoples and with other nations that has been absent for 8 years. But what is missing yet, and I'm hoping that it's not going to be missing for a long time, is an ability to lead by example, by reckoning with the violations of that happen in the context of the global war on terror, and clearing the U.S.'s own record, so that we can then tell other nations, you have to reckon with your past, you have to do justice to your victims, you have to tell the truth. So what I'm going to say about it is, I don't want to exceed the time because I know you may be interested in more of a dialogue. But first we have to understand the extent and scope of the violations that have gone on in these 8 years. Because for some human rights violations, the remedy, it is enough for a remedy to be, let's just stop the violation. Say, for example, voting rights or freedom of expression, press censorship, for example. It is enough to put a stop to the violation and then go on. But for certain types of crimes, that's just not enough. The appropriate remedy has to be a serious investigation and an accountability for them. And here we just to enumerate some of the problems that the kind of like the list of violations that we have to look at is first the issue of detention, that has been prolonged, arbitrary, and without trial. There's a variety of reasons why this is wrong. There's also very good arguments, or very interesting arguments as to why if you just call it a war, then it's okay. Even that is disputed by those who really know international humanitarian law or the laws of war. But let's say that even if prolonged arbitrary detention is justified by war, it doesn't explain why in Guantanamo there are people who were never caught in any kind of theater of war. They were caught by other governments and given to the United States. And there were people caught even in the United States territory that have been held for years without trial. And then there's Guantanamo. We have an announcement that it will be closed, and that's going to go a long way in improving the image of the United States in the whole world, but it's going to take a while, and we have to keep pressing hard for that to happen. But many of the people in Guantanamo and elsewhere have been subjected to military commissions that the Supreme Court itself has said, and probably have to say again, because the Bush administration managed to reenact a law basically skirting the clear provisions of the decision by the Supreme Court. Military commissions that have no semblance of due process or fair trial or independence of the judiciary. There's also torture and mistreatment. First, we thought there were only the memos authorizing torture. Now we know through the Mark Danner article that the torture has been cruel, has been savage, has been really embarrassing to read, that in the name of the United States government, people have been treated the way they have been treated. So it's the memos, but it's the memos leading to and facilitating the commission of torture. it's not just, parsing and kind of depriving words of their meaning by the memos by Judge Beebe, for example, that it's only torture if it results in organ failure or in death. It's no longer a question of whether waterboarding amounts to torture or not. I mean, I don't know that anybody can feel that it's a minor, form of violence. When what happens in waterboarding is that you feel that your lungs are going to explode, literally. There's also extraordinary renditions, and there, by that I mean, as you know, passing a prisoner on to another government for the purpose of being interrogated under torture. Let's just not put too fine a point on it. Because if they didn't, even though they get assurances that they won't be mistreated, if they have a high-value prisoner, as they said, and why would they give it to Egypt, Morocco, other countries, if it wasn't for the purpose of being tortured? I mean, how much do we have to let our own intelligence be insulted by people who say, well, we sought assurances that they were not going to be tortured? Then there's obviously issues of surveillance. There's abuses of immigration law and regulations, especially at first. As you remember, there were some, we never really knew, maybe 1,200 people arrested. The names were never given to anybody. They didn't tell us where they were, and they were, within a few months deported. I mean, that's another serious violation that we have kind of forgotten, maybe because the others were so much worse. And there's laws of war violations in Afghanistan and Iraq. I mean, it was almost embarrassing to read how many times a wedding party had been bombed because they had been firing into the air, and our forces thought that they might be Al-Qaeda or other insurgents. And then there's a cursory investigation and basically no more. We also have to understand not just the extent and scope of the violations, but the extent of the impunity for them. First, in Abu Ghraib, for example, the investigations have been so cursory, and the resulting convictions have really scapegoated the people less powerful in the chain in which these things happen. And they haven't gone beyond, a sergeant, I think, is one of the defendants who have been convicted. Then through the Freedom of Information Act, the ACLU has discovered something like 50-some investigations conducted in Iraq and Afghanistan, investigations by the Pentagon, and they are appalling for the lack of professionalism, I would say. The investigators have instructions not to ask anybody but the U.S. military. They can't ask victims. They can't ask eyewitnesses. They are instructed not to go beyond a certain level of the chain of command. And so, almost inevitably, they end in nothing. They end in no serious investigation. I mean, if those investigations were conducted by the Pinochet army or or any of the armies of Africa, we would be decrying. We would say, that those are not serious investigations. They are meant to result in impunity, and therefore they are unacceptable. So we know that we basically know the tip of the iceberg. I mean, we just don't know how much. Even in the question of the torture memos, it appears now that there are many more memos that are much more explicit and specific, written by perhaps the same cast of actors. Somebody the other day at a BBC interview, a panel in which I was participating as well, a professor from England called them the Bush lawyers, and then said Bush lawyers in more ways than one, because it's the same actors, John Yoo, Jay Beebe, and all of those. Apparently there are more memos that are more explicit and more clearly directed to authorizing and permitting extreme forms of torture. So what needs to happen, it's good to know that some things have happened already. the executive orders by President Obama the first day in office are very significant steps in the right direction, and we should not forget them. The executive order that for now on torture is prohibited under all circumstances, that the Geneva Conventions will be respected in all relevant circumstances, that the Uniform Code of Military Justice will always apply, is very significant. The decision to close Guantanamo is very significant. The review of the Military Commissions Act is also very significant. And more recently, the fact that the CIA has been prohibited from using the black holes detention centers is also very significant. But we still don't have a clear policy on prohibiting extraordinary renditions, and we are still relying on secrecy at trial that basically deprives some victims of a remedy, because the United States still holds that revealing certain things would be detrimental to the security of this country. So what needs to happen is, and I'll finish with this, is a commission of inquiry. I mean, there's debates about whether we should go straight to prosecutions. I tend to think that prosecutions can wait. Well, maybe because of statute of limitations they shouldn't wait very long, but they can wait. We first have to get to the bottom of what we don't know right now. And the initiatives in Congress to create a commission of inquiry should be supported and perhaps even led by the executive branch. Because what we don't want is a bipartisan commission with equal number of Republicans and Democrats, because that's a recipe for failure. I know there's very good examples of good commissions formed that way that did a good job, but there's also bad examples, like the Iran-Contra Commission, for example, that didn't go that way. What we want is a non-partisan commission, a commission with a composition of very highly respected people drawn from different walks of life, that by their own presence can give credibility to the commission. But then many other things have to be decided as well. Whether they can have subpoena powers, for that you need some congressional delegation of powers, whether, what kind of resources are going to be put in their disposal, what kind of staffing they're going to have, and the mandate, and how long the mandate should last for. But I think if done well, and the United States has the resources to do a very good commission of inquiry, then that commission should issue recommendations that would have a very, very high level of weight and credibility, and there the decisions to prosecute or to give immunities to some people should follow from those recommendations. The same with reparations, the same with institutional reform. A commission like that can put us in the path of reckoning with the past in a very good way. And the last thing that I want to say is that the one thing that we shouldn't do is a commission of inquiry that is premised on the fact that there's not going to be prosecutions afterwards. Some people feel that a commission of inquiry, by definition, is premised that way, and that's not true. That's not the way most of the more successful commissions of truth commissions around the world have functioned. On the contrary, they've been a step in the direction of accountability, and if they were premised on there is going to be no prosecutions, they generally have failed. So it's okay to leave the decision to prosecute for later, but one thing that should not happen is either a blanket amnesty as a condition to having the commission of inquiry, or misuse of the immunities that the commission could offer that would render prosecutions down the road much more difficult. I'm sorry I've gone much longer than Susan allowed me to do, but I hope that we can now enter into a discussion about these things, because I'm really eager to hear your comments. Thank you very much.
Well, yeah, I mean, it's really 7.
Oh, 7. So we have 20 minutes?
We do have, I told Juan, we can do about 10, 15 minutes of questions, and then we will have a reception that people can talk to Juan E, catered by our friends from Petite Folie, so you're invited to stick around for good food, which is also part of the Kirshner family traditions.
So maybe I can recognize 3 or 4 and then...
Sure. Do we have some questions?
Should I recognize it myself, or do you want to? Okay.
I actually have a question.
You
I'll
have
give
one?
you the first question. The first question is, how do you think the potential indictment of these 6 high-level officials of the Bush administration in Spain is going to impact our capacity to have our own process here?
Okay. Well, I can answer that while people warm up to other questions. What I hope will happen is that it will, generate attention to the matter in the United States, and a decision by whoever has to make the decision that if we don't want these former officials to be prosecuted in a foreign country, then we have to do the right thing here. But I'm insisting that that's what I hope will happen. Unfortunately, I'm a little less optimistic that that's what's going to happen. I think I've read the brief submitted to Judge Garzón by the lawyers who started this in Spain, and it's a really interesting brief. It's mostly about the responsibilities of lawyers, and that's why it's focused on González et al. But it seems to me like the effect that it can have in the United States is like the Wall Street Journal editorial that already came out, basically defending United States sovereignty under any circumstance, and not even saying it's sovereignty to do the right thing ourselves. No, it's sovereignty, period. It's sovereignty to decide to let these guys get away with it if we so decide. So it's obviously the editorial is very self-serving and wrong in that sense, but I'm afraid that it can generate that kind of attitude that is, that can become a distraction from what we need to do. I think it's also a little premature, quite frankly, because Obama has been in the White House only since January. And although I know that the universal jurisdiction statute in Spain doesn't have any requirement of ceding to the territorial state's own ability to prosecute, but it should. I mean, as a matter of discretion, it should. I mean, there's really no reason why Judge Garzón has to try all the cases that happen everywhere in the world. There is a very good reason for him to go after Pinochet, because there was complete and total impunity in Chile until he did that. Fortunately, the effect of that has been that now there's no impunity in Chile, and even that Pinochet did not die an innocent man, because at least he was under prosecution when he died. So, well, maybe he was an innocent man under criminal law, but he was not. There was an attempt to prosecute him anyway. So I fear, quite frankly, that in this case it is premature. I mean, the United States can still do the right thing here, and there's really no reason for this to happen. I have to say that the way it was reported is a little misleading as well, because all that has happened so far is that these lawyers have submitted a brief, and that Garzón has asked the prosecutors to give their legal opinion. And that's all. Now, obviously, he could have done even less than that and just basically reject the brief out of hand. But I don't think he is right now saying, as soon as I get a hold of them, I'm going to prosecute them, and they better not come to Europe because we'll arrest them. That is far from being the case yet. I mean, it could happen, but it's not where we're at right now in that case. Yes?
We need this for recording purposes.
You pointed out that the calls for inquiry about some of the actions in the past administration are really coming from Congress, and that the executive branch has been telling us it's more valued to look forward than to look backward. What are the factors that are influencing the executive decision there?
Right. Well, I didn't say it, but I'm glad that you said it, because it's something that I should have mentioned. I think the administration is not, is not leading the charge here, but is not putting obstacles on this either. The initiative may be coming from Congress, but Obama himself and Eric Holder have both said already that no one is above the law, so that should be an encouraging sign. But I think it shows that it's also true that during the campaign, President Obama said many times, and he has said it more recently as well, that he prefers to look to the future, etc. But if you put that together with no one being above the law, I think there's an argument for looking to the future and also dealing with the past effectively. I am encouraged by the fact that the matter continues to have a lot of currency in public opinion, and that the opinion polls show, a very, very high percentage of people in favor of getting to the bottom of this. But I also think it's important that we get to the bottom of this in an orderly, very clear, very serious fashion, that it doesn't appear to be a kind of a, getting back at the Republicans kind of attitude. I am discouraged by the fact that the Republicans are really closing ranks here. Senator Leahy cannot get a single Republican to, let alone McCain, who was on the record back when, in favor of investigating torture and prohibiting torture. He can't get anybody to sign on to his bill to create a congressional commission of inquiry in that case. That's very unfortunate, because it should not be a bipartisan issue. It should be a matter of individual responsibility, and I think I really don't know why Republicans that have parted with the Bush administration on matters like the economic crisis and the financial crisis and all of that want to close rank on this issue so closely. I mean, maybe because they think that the Obama administration is vulnerable on issues of national security, but I don't see evidence of that either. So in sum, I think what we have to understand is that it's up to us. Up to us meaning common American men and women, the citizenry, the polity of this country, to insist, to come up with ideas, to develop the framework in which we have to do this, to talk to Congress and to the administration, and to find the appropriate ways of doing this. That we cannot, but we also should not rely on Barack Obama, doing the work for us. And I do think that if we do find the appropriate mechanisms and the appropriate ideas to do it, and we gather momentum, I am certain that the administration will not be an obstacle. On the contrary, it will come along. Okay, I have two questions over there. This time I'll try my answers to be a little shorter. Go ahead.
Has anyone been tried using the U.S. ban on torture that was signed in 1990 yet, particularly U.S. government officials?
You mean the U.S. statute that enforces that implements the Convention Against Torture? I think the only case that I know of is Chucky Taylor, the son of Charles Taylor, who was successfully prosecuted in Florida. I think it's the only case that I know, and that's interesting because it's the first case of universal jurisdiction applied in the United States. So that's a good argument against the Wall Street Journal. I mean, they didn't decry that the U.S. judge was interfering with the sovereignty of Liberia when Chucky Taylor was convicted.
So could it be applicable to torture that occurred in the United States?
Well, that statute would not be applicable, but there are plenty of other statutes that are applicable. I mean, there have been some cases dealing with Abu Ghraib, but as I said, they've dealt basically with those who had the bad judgment of appearing in the photographs. Lindy England and the other young woman who appears pointing to someone as if it were a joke. Those are the people who have been prosecuted and punished, and not very severely either, quite frankly. But their superiors, the people who gave them the orders, the people who let it happen, the people who didn't investigate, the people who were supposed to know what was going on and should have known and could have known, those people were not even investigated.
You mentioned that it's such a problem that people just forget about the crimes of the past, and I think that there are so many people who have suffered these atrocities who continue to suffer them and don't forget, and hopefully they'll come forward.
That's right. I agree.
So I'm a little bit curious about why most of your suggestions or your proposals have to do only with the last 8 years. Wouldn't it be more convenient, both morally and politically, to extend this type of general kind of investigation to other instances of domestic abuses
that could have happened
in the U.S. back in history, in the U.S. and abroad, in order to, for the purpose of a more general reckoning or whatever.
The only problem is that if you go very far back in time and you start, deciding where you draw the line and all that, then the mandate of the Commission of Inquiry becomes unmanageable. But I didn't mean to say that it would only focus from September 11, 2001 on. For example, renditions, one could explore. So there were some renditions done during the Clinton administration, but the Clinton administration claims, and maybe that would be a good thing to investigate, that they were different from the extraordinary renditions, because renditions for the purpose of trial in a foreign country, that is kind of like, it's a way of circumventing extradition procedures, but it's not illegal. I mean, it's arguable, but it's not illegal. But renditions not for prosecution and trial, but for interrogation and torture, that's what we call extraordinary renditions. And even the Bush administration distinguished between the two. So it's a little, I mean, maybe, as a matter of cutoff date, or starting date, actually, for what's to be investigated, I completely agree. I mean, it shouldn't be an artificial date. It should be one that allows us to look into precedent, especially if the Bush administration has been saying, this thing were happening before, so let's investigate what happened before as well. But if I spoke only about the last 8 years, I didn't mean to say that that's all we have to investigate. No, I agree with you.
We have time for one or two more questions.
You talked about the fact that the people who are actually tried for torture were those who appeared in the photos, and you talked about the fact that the humanitarian organizations on the ground, just the fact that they're there to bear witness, they stop atrocities from happening. So I was wondering if in high-level policy circles, people are talking about the potential for technology which lets photographs, lets witness bearing spread so rapidly, the potential that could have for changing the human rights apparatus.
Yeah. Well, yes, they are. In fact, a lot of what happened in Darfur was discovered early on through satellite photography, etc. The thing is, when I was a special advisor, the State Department showed me some of those things, but they didn't show me, the technology or how, because they wanted to protect intelligence secrets, and it's very difficult to know what to make of something. They tell you, they see when it's yellow, that means that's a village destroyed, and what kind of evidence is that for what you have to do? I still think it's useful. It's not evidence that's very solid, but it's useful, and it's important for preventive purposes. Maybe not for adjudicating and prosecutorial purposes eventually, But for preventive purposes, it is important to persuade intelligence agencies generally, not only the United States and hopefully many more, to share information. They do now, but they are pretty reticent about what information they share, and there's always the sense that if they share some but not all, you really don't know whether they're not really, kind of putting their own spin on the information. So I think it's a little less than useful, but it's also true that technology now can be used outside of intelligence gathering as well. I mean, a very entrepreneurial kid from a university came to me and showed me how to use Google Earth to find, evidence of destruction and to track evidence of new destruction in Darfur. Now, I can't say that I mastered it, but I think it's very promising, and it's not tainted by the policies of a certain country. So that's very, very useful. One more?
One more. Lucy.
Two more.
Okay, then who's the second? Okay.
I wonder if you think that if the U.S. appointed a special envoy for Darfur, whether that would have an impact on alleviating the situation there?
Well, President Obama has appointed a special envoy, I think an admiral or a general called Gratian. He's just started, so it's difficult to know what impact he's having. I also think there is an ambassador at large for war crimes that has been continued from the Bush administration, Clint Williamson, who has done a very good job, and for now at least is still the ambassador at large for war crimes. And I think those things are very important. I mean, if you, at the very least, you signal the importance that you give to a certain conflict or a certain issue by appointing a special envoy. I think when the Bush administration had Senator Danforth as a special envoy for Sudan, he did a lot of good. Unfortunately, when he left, no other special envoy was appointed, and the matter of Darfur, well, all of Sudan, but especially Darfur, kind of drifted in and out of the interest of the Bush administration. And that really, although, the Bush administration, to its credit, was of the P5 the most forceful on Darfur. Not to say much, quite frankly, by saying that, but even if it had all the good intention of doing the right thing in Darfur, which I think they did, they defeated their own purpose by not putting Darfur very high in the agenda, and by letting Khartoum get the impression, which I thought was the right impression, that Darfur was not a very high priority because we're otherwise engaged in Iraq and Afghanistan and every other North Korea, all kinds of other issues, and so they didn't need to pay too much attention. Yes.
Would you say a little more about the tension between justice and reconciliation? You talked about it with respect to large groups who need to reconcile after conflict. What about the role of reconciliation where groups are smaller or even individual perpetrators and individual victims?
Right. Well, I think reconciliation has been the general objective and the legitimizing principle under which we do everything that we call transitional justice. In Latin America, especially, we don't use the word reconciliation, but that's only because in Latin America it got a bad name, because people who use the word reconciliation were really talking about impunity. They would say, we're not going to do trials and we're not going to do truth commissions because we are reconciled. And that kind of forced reconciliation really gave the word a very bad name in Latin America, so nobody uses it. Unfortunately, some Latin American human rights groups have gone way beyond that, and they feel that in every context reconciliation means impunity, and that's just not true. And I do think that even in Latin America, the ultimate purpose is to have a reconciliation, a national reconciliation. That meaning by that the parties that were resorting to violence before now will no longer resort to violence. It's as simple as that, and who could object to it, right? But the concept of truth and reconciliation or justice and reconciliation comes mostly from the South African experience, because the word reconciliation is there, but it was also there in the Chilean Truth Commission, and it is in the Peruvian Truth Commission that is much later. The problem is that a lot of people think that the example of South Africa is that you do truth and through the truth you do reconciliation, and that you very deliberately forego all possibilities of prosecution and trial. And that's not even true of what was the purpose or what actually happened in South Africa. But unfortunately, there's been the myth has been created that if you want reconciliation, you do a truth commission and you don't prosecute, and that in some countries victims are more forgiving than in other countries. And I don't believe that's true. I think victims want to be able to forgive, but first they have to see justice done. They have to be able to determine for themselves whether they want to forgive or not through state policy. So in the end, I think reconciliation is first and foremost the underlying principle and the objective for which we do all of these things. But it has to be understood in its proper terms, and especially it has to be understood in the terms that that if we want reconciliation, some things have to happen so that we get there. Reconciliation cannot be the decree by which we decide not to do anything because we impose some form of reconciliation on the victims. And particularly reconciliation between warring groups or between ethnic groups is one thing. But in some cases where you ask the victims of torture to be reconciled with the torturer, and you don't even ask, you impose it, that's very offensive, I think. And so it's really more a matter of what we really mean by reconciliation. But anyway,
It's a good time.
long.
Thank you.